Thank you for the introduction and thank you for the wonderful presentation made by Dr. Khalid Hamid Chaudhry, whom I have known, I think we all have, for ages. It was such a brilliant presentation, needs no introduction at all, and especially when I'm here on the stage to say a few words. He has already covered everything, and I really don't know what to say. I was speaking to my colleague, Mr. Justice Khurshid Alam Sharkar. What am I going to say? Because he's already said everything, and especially the Queen's Counsel who is here, the senior advocate, he also said the same thing. And what I wanted to tell, and what I wanted to tell the audience, it is actually in the mobile set of the QC, the Queen's Counsel, Mr. Ajmal al-Hussain. So based on those two observations, and the third one is this Anil, who has come from Singapore. He's such an expert, so needs nothing. There's nothing for me to say actually. But since I've been called up on the dais, I will say a few words as the mediator had already asked me to say so. Can you all hear me? Yeah. Very loud and clear? Yeah. Good. Sorry that I had to ask, because every time I'm on the stage, I'm not a good speaker, I'm a good listener. By this time, on the 11th year on the bench, I've become a very good listener and not a good speaker. So I've really forgotten how to speak. As we all know, that the Arbitration Act of 2001 is the primary statute for the government laws with regard to arbitration in Bangladesh, and was drafted based on the UNCITRAL model law. Arbitrations are done to avoid litigations, which are more time-consuming, and hence commercial transactions nowadays ventures for arbitrations more, and in other words, settlement outside the court. We all know, but just to remind ourselves once again, Bangladesh is a party to the New York Convention and the Exit Convention 1965. The 2001 Act provides for enforcement of foreign arbitral in accordance with the New York Convention, and the scope of application of the Act in general limited to arbitration taking place within the territory of Bangladesh. Now coming, since I've been on the writ bench for several years, as far as my memory goes, only with a few years, few months on the criminal bench. I have seen, from my personal view, which we do is this, there are two types of arbitration, as we say, institutional arbitration, and the other one is an ad hoc arbitration. We always say Article 102 is there when no other equally efficacious remedy is available. High Court Division would interfere in exercising its extraordinary jurisdiction. But when it comes to commercial contracts, when it comes to arbitration clauses, we say that the writ is not maintainable when there is a clause of arbitration. Am I talking a bit fast? Are you sure? Kono reaction dekhte parchi na, so I think I'm speaking a bit too fast. I know I speak a bit fast, but the time limit, I'm not too sure when I'm going to be shown the card, because Mr. Masood had told me he's going to show me a green card, a yellow card, and a red card. So I'm still seeing here and there, where is the green card? So since, after 10 minutes, okay, whatever it is. So going back, the writ we say in our courts, in our courts means the writ jurisdiction under Article 102 of the Constitution, the remedies that you come for an aggrieved person. So we always ask, how are you an aggrieved person? And naturally, the aggrieved person says, I'm aggrieved because the agreement which we signed could not be completed, number one, and then would say that the agreement was not fulfilled, and would say that, he has taken the money and was supposed to do the work. And so the only question that we ask is, not the only question, number one question is how he is aggrieved, and the second question is, was there an arbitration clause in the agreement? There are arbitration clauses in most of the agreements, actually. So what we do, we say, in the first place, that your writ is not maintainable. So just because we say a writ is not maintainable, just not brush aside the grievances of the aggrieved party who is before the court. Because if there is a fraud, if there is something that goes beyond public policy, of course the agreement would not sustain. So even if there is an arbitration clause, in the statutory arbitration, we say, suppose in one of the cases that we conducted and given a judgment, it had gone to the Appellate Division as well. The petitioner was a consumer of gas under the Cornfully Gas Distribution Company, who entered into agreement for such consumption of gas, and of course there were terms and conditions therein. And as far as I can remember, one of the clauses of the Gas Act, of the contract, stipulated that there be any disputes arising between the parties. The parties shall refer the matter to arbitration. So one of them had come, of course, the petitioner had come and said that even though there is a clause in the agreement for arbitration, but the arbitration would take a longer time, and Article 102 is a speedy recovery, efficacious remedy for allowing us to be here. So please do consider our petition, and so that the writ is maintainable. On the other hand, the respondent side, as we say, the Section 26 they had referred, the Section 26 of the Bangladesh Gas Act of 2010, that had stipulated that any dispute between the consumers and the gas company shall have to be resolved, none other than by way of arbitration, and in view of the provisions under the Arbitration Act of 2001, which we have referred already. So we said that since there is this clause in the agreement, so we said the dispute has to be resolved between the parties through the commission constituted by the Act. So which Act am I talking about? The Arbitration Act, no, but the Bangladesh Gas Act of 2010. So we did refer that since there is already a commission mentioned in the Bangladesh Gas Act of 2010, the parties must refer the matter to the arbitration for arbitration and shall have to go to that commission. But we added, if we did give a specified time, Khalid Hamid Chaudhry has already mentioned about the time frame and said that there is a lacuna that we do not know, the time frame is not there, so which becomes like quite an impossible task as to when it is going to end. So we, since we exercise our discretionary power sitting under Article 102, we said the appropriate forum obviously is the Bangladesh Energy Regulatory Commission, and dispute the azan is, shall we stop or? Okay, so the dispute settlement regulations of 2014 for resolving the dispute, but since the petitioner did not comply with the direction passed by the division, and since the Bangladesh Energy Regulatory Commission Act as well as the Bangladesh Gas Act of 2010 specifically provided alternative dispute resolution, the parties, we said, were to go and avail that forum instead of coming to jurisdiction. There have been several, several cases, but because of time frame, I've already been given the green card. I can see that. But one of the judgments that I would refer to is by the Appellate Division, which is reported it's a civil petition for leave to appeal 1484 and 1485 of 2016, and was decided on 21/8/27, where they said that the alternative forum is there, writ is not maintainable. And in another judgment, reported in 69 JLR, Civil Appeal number 15 of 2010, and that was also with regard to a commercial tender. It was challenged on the ground of interference, right to profession, business, livelihood is a classified right. So the petitioner was actually debarred from participating in rural electrification boards in all the bids, and the petitioner had said in the High Court that he was not shown any reason for assigning any reason on the notice. He was not given any notice, so it was like no notice was served upon him before he was renewal was cancelled. So renewal for his enlistment license was to be arbitrary, and we said that right of the petitioner to participate as an enlisted contractor of REB just cannot be taken away without assigning any reason. The orange card comes in. So last but not the least, I will say before the red card comes in, I have never had a red card enter in my life in my report card. So I don't want to get a red card now. So all I want to say is this, that before any dispute arises between the parties, if there is an arbitration clause, the parties must refer the matter to arbitration. As I have already said, there is statutory arbitration as well as an ad hoc arbitration. One is, of course, a very formal one, and the other one is the informal one. Thank you so much for your kind attention, and I would love to answer to any of the queries after the panelists say. Thank you.
In his discussion, I would request him to highlight